I think we're talking about a very interesting topic for mediators, particularly new mediators today, which is practice management. Before I proceed, I'd like to acknowledge Aboriginal and Torres Strait Islander peoples as traditional owners and custodians of country and recognise their continued connection to the lands, waters and culture, and pay respects to elders past and present. I'm on beautiful Gunai Kurunai country in Victoria, Joe. If you wouldn't mind taking a moment just to introduce yourself in the chat and let us know where you are and whether you're an AMDRAS student or accredited or something else. And also if there's any specific questions that you'd like to make sure that I cover off on today. What I have planned for you is to make sure that we're all on the same page with the AMDRAS standards. We're now operating under AMDRAS. You're AMDRAS accredited mediators. If you're still calling yourself an NMAS or an EMAS mediator, please stop and change to AMDRAS. We'll have a look at some of the essential information that you need, a professional practice, some sample documents, and for members where they are. And we'll have a little bit of a chat about some of the case management, confidentiality, record keeping, and I've got a few examples of some of the issues that tend to come up with members in terms of complaints, so things to watch out for in your management of professional practice. This is the AMDRAS website. It's now fully in effect. It came into effect, the transition period ended on the 1st of July this year. So we had that 12-month transition. Let's see if this will play. So where to go to find the AMDRAS is up in the resources, and then you've got a copy of the AMDRAS. I'm referring to it. It starts in the middle where it was last time. There's a very comprehensive table of contents. A lot of what's there isn't necessarily relevant for you as mediators, training and all of that sort of thing. But now that we've got the new levels of accreditation, certainly the practicum and further advanced is relevant for you as well. The area that you do really need to review, if you haven't already, is the professional practice domains, which look at your professional knowledge, skills, ethics and responsibilities, and professional development. And it's got a lot more information than used to be in the NMAS for anyone who is familiar with that document. I would really encourage everyone to read through this, think about your professional practice, your documentation, and how it is that you're complying with those elements. There's also now a code of ethics in the standards, whereas before it was kind of assumed within the standards. I'll go quick through this bit, which isn't so relevant to you as practitioners. The AMDRAS now has appendices which are part of the document, and it's got information about your professional development requirements and further detail. And don't worry, it's going. I've gone through quickly so that you have to go to the document and check it if you haven't already done so. Further detail about what those key high-level things meant in terms of how they're articulated into our standards. There's also your CPD schedule and record sheet. In your members area, there's a tool you can use to record your CPD, and when you attend events like this, generally we'll update that for you automatically if you've registered through MI members. Depending on the level of accreditation you've got, your practice hours are higher. So 20 hours is the minimum as an accredited mediator. Magic Rowena in the background said you've all been marked off. You've been ticked off on the roll call. What it has in the standards is a list of the types of activities, how many hours you can claim. If you do more hours than that, great, but you can only claim the total amount. So see that example there. This is a template. Here's our code of ethics and expectations. What I really would encourage you is think about how you are embodying this both in your professional practice and also your documents, so that you're very clear about things like declaring conflicts of interest, if there's any potential that would be there. That's enough of that, because we could spend all day just looking at little bits of the document. So what I want to talk about now, and please, if you do have any questions as we're going through, just ask them, either hand up, use your voice, use chat.
Can I ask one? Where it says attending and confirm attendance,
Yep.
attended, a lot of mine on a confirm attendant isn't marked for some reason. They're all marked on attending, but not on confirmed attendant.
Okay. When you go into, and my members do.
Yeah.
Okay, well, Rowena will make a note of that, and we'll have a look at that tomorrow.
Okay, thanks.
No problem. Just as an overview, some of the differences now is that we've got our professional knowledge, our skills, our ethics, and our professional development into those 4 practice domains. We've got the tiered levels of accreditation. The specialist dispute resolution categories are new as well. The first specialisation, which is elder mediation, is going to be approved soon. So that's exciting. And there's some additional skills and knowledge that's needed working in that area, because there's the challenges of capacity, and they're usually, or pretty much always, multi-party mediations as well. So there's some extra skills needed there. As I said before, and you saw flash quickly past you on the screen, the practice hours and CPD hours have changed. So for accredited mediators, they used to be 25 hours. It's now 20 hours of practice minimum for 2 years. So it's quite low. But if you're only mediating part-time, or you're struggling to get into mediation, it's still a challenge for some. What the standards now allow is up to 5 hours of observing a more experienced practitioner, and up to 5 hours of intake and pre-mediation work. So that 20 hours is actually 10 hours of mediation. For more experienced practitioners, you can expand your network by allowing a novice come in and observe you in all your glory. that can be valuable for you and for them. And it's 25 hours of CPD. For people that want to be advanced or leading, you need to have a minimum of 40 hours of practice. Our code of ethics is something that you really need to be very aware of and using for guidance for your professional practice. And complaint handling, having an independent complaint handling service is mandatory. It's a mandatory part of your accreditation. If you're a Mediation Institute member, that's provided to you as part of your membership. And the same thing, professional indemnity insurance is a requirement for everyone. We've got an arrangement now where we've been able to negotiate some member benefits with Aon, so you can get a quote with them and either use your member number or a test code to get that. I think at the moment you get 3 extra months or bonus months of insurance. John?
Yeah, well, I'm probably going to ask how long's a piece of string here. I know when we did our accreditation, our mediation sessions ran for an hour and a half, but I'm just wondering what industry average is for mediation sessions.
Look, it depends a little bit in context. For me, it's usually about 3 hours. Joe, Craig, round about there. Some people do half day, full day. It tends to be more the commercial mediation where there's lawyers and others, so herding everyone together. They kind of do that. Nalika, what about you?
I am still yet to do the actual mediation. I have done some workplace facilitations. Other than that, this is the issue, how you start.
I think 2 or 3 hours, depends on the context. Sometimes workplace they do 2 hours, and people say, oh, we won't take long, an hour is going to be fine. It's never.
No, yeah, I mean, like I booked one for 2 hours, but it's actually ended up in 3 hours.
Yeah,
and it's still not finished.
Exactly. So 3 tends to be a good mix. Too much more than that, people get quite tired. For example, with elder mediation, I wouldn't even dream of that. And it's really managing expectations for clients. When you do your pre-mediation, there's a whole lot of things. You say, well, it might take a couple of sessions to get through everything.
Facilitated conversations count as well to the CPD?
If you're working as a third-party independent, that can count within your practice hours. You need to be not representing clients or working as one own. Some of the core documents that are really essential, the most essential is your agreement to mediate. Please, please, please always have an agreement to mediate. Have it comprehensive so that it articulates who you are, what you do, how you do it, what services cost, what happens if someone doesn't show up and they've already paid, and all of those sorts of things. It can make it quite a big document, but it is much better to have that, because if I get a complaint and there's no agreement to mediate, just a couple of dodgy emails, the person hasn't really complied with their requirements. So we've got some examples, and I'll show you where there's a basic example as a start, but tailor it to your type of mediation. You might have a couple of different ones depending on if you do different types of mediation. If you're doing facilitated discussions, you're going to modify what the confidentiality is. Sometimes workplace ones can be quite brief with the parties, but then you've got another level with the organisation, because it's the organisation that's paying you and the parties that are being sent, but they still have a right to understand what this thing is that you're going to do with them. You can't just herd people into a room and talk. I encourage you to have a standard letter of invitation that you send out, an acknowledgement if you're using standard letters. That way you're not falling in the trap of becoming too friendly. We're friendly, but we're not their friends. And having the structure, having the links to further information, whether on your website if you're using a website or just in documents, that's a lot better structure as far as that's concerned. Intake forms, so really important. And again, having variation. So if you're doing work in a couple of areas, for example, Jo's a family dispute resolution practitioner, her intake form for that's very different to what it would be if it was a relationship mediation with a couple that aren't going
and property.
And yeah, absolutely. So really thinking through. I would strongly encourage you that you do use an intake form. Don't just use a bit of paper and ask some random questions. That way you know you're asking the same sorts of things to both parties and being even-handed in your process. We all come with this pretty strong set of inbuilt biases that we don't even know about. So that's one of the things that we need to be constantly battling against as mediators, to make sure that we don't make assumptions or think this nicely presented person, I won't ask them those sorts of things, because clearly they wouldn't be like that. There's no way to see from the outside. You might like to have a heads of agreement document that you can use to put a little bit of frame around the agreement, that might have some guidance around context and whether the agreement mediation is going to be binding, whether they're intending to get it turned into orders or anything like that. If you are using something like that, you're not starting with a blank piece of paper, I would encourage you to share the template with people beforehand. So if you've got some information in there that's going to be in their agreement that they haven't told you, they should know in advance, because then they can say, oh, well, I don't want it to say that, or whatever. Links about that. Privacy policy, really important to think about it. We know that we've got confidentiality and common law protections as mediators, but we've still got obligations around people's private and confidential information under normal business practice. So think about that as well. How are you going to store and keep and manage people's information, both as a mediator, but just as a business person? And again, it might be in your agreement to mediate, or there might be somewhere else that you've just got a little link. So if you've got a website, it's kind of tidy to have them that way. But fees and expectations, definitely, you need to provide that to people in advance. So there's no question about that. It might be in your document, or it might be a separate fees document that you get people sign. Again, think about the context that you're working in and your complaint handling policy. So it's really important that you are very clear and upfront to people how they can make a complaint. Ideally, invite them to talk to you first and make that easy. Sometimes we get grievances, which are complaints about complaints, because they've had to go looking around to try and find out who to escalate the complaint with, which isn't good. They might contact the AMDRAS board. If you're working in family, they'll contact the Attorney General's department. They'll often contact Mediation Institute because they do a thing, and it doesn't matter whether the complaint handling provider or not. I've got this complaint about this person because they did this or that. So it's much better if it's nice, clean and clear to them how they can escalate. So those that are out working, are there any other core documents that you think are absolutely essential?
Quite a few of what you've already mentioned, Jo, I use myself. What's really important for me, what I send to any of the clients when they first start, is an information booklet. So that clearly says how, why, where, what, when, and also includes the complaints, and they have a link to click on that. Some of that information is in my standard agreement. It shows the process. This is how we're going about it. These are the fees. This is the complaint policy, and click on that and they can go to that policy. But also it lets them clearly know the time frame from the time they start and what I do with step 1, step 2, and so on. I found that very important over the years. I've changed that to suit the updates with our regulations and with family law, given the changes too with family law, with parenting, and so too with property. In that section in my information document, there is one about property, one about parenting, and hyperlinks to go to the government website to download those particular documents themselves, but also importantly about disclosure too.
Yeah, absolutely. So you can refer people through your documents to appropriate sites. So you're meant to explain, in AMDRAS that you're a nationally accredited mediator, and you can link to the standards or the AMDRAS website. And for FDR, you can link through to some of the mandatory court information. You can also think about if you're getting into video and all of that sort of thing, you can have a video information thing that you put up on YouTube or Instagram or wherever. But that's a supplement to your official documents. So make sure that you still got evidence and you're getting people to sign the agreement to mediate. This is just a couple of the pages of an example one that we've got for members, and I'll show you where they are. It doesn't need to be a huge amount of information, but it's very important that we're very clear about things. I encourage you not to use legalese. Make it as understandable as possible, because accessibility is one of the requirements under the standards, that you try and make your services as accessible as possible. And so using language that people can't understand isn't a great way to do that. So just a couple of things around privacy, and I think I've got something about the privacy principles. Most of us as small business owners, unless you're over $3 million, you're not required to be signed up to the privacy principles, but they're actually a really good way for you to double check your business approaches. Oh, look, everyone's interested in how you're putting that together. So that's great if you're comfortable with that. So just be mindful that Jo's mainly family dispute resolution, but I'm sure if you've got one for your other work as well.
Sure.
So compliance with privacy legislation, don't be a spammer. Make sure you've got permission to send information to people, and think about what information you collect and how you store it. Are you collecting information that isn't required? As mediators, we do collect a lot of personal and private information. So think about how are you keeping that information confidential. So if you're prone to paper and you need a locked cupboard, don't just have them sitting on your shelf where someone can wander in, particularly if you've got a public office. Make sure that if you are disposing of client records, you shred them or dispose of them in another way that's not going to have them turning up, flying around it in the local tip.
For mine, Jo, I'm a creature of habit. I write when I have an intake. I write the information, scribble it, and then I scan it. And once that's done, it's then saved in the folder of the client. But that's then also saved on an external hard drive. So if anything was ever stolen from my laptop, no one could see it because it's on an external hard drive. And I keep 2 copies. So that way, if something disappeared generally, I've got another copy. But the paper I still keep as well. And I have that in a locked cupboard.
Yeah.
And my office is locked. So if anyone came in, they'd have to try and take a big cupboard. Interestingly, Jo, we were talking earlier about the length of time, because before we had to keep our documents for a while.
Yeah.
And now it's 2 years, and then with other things it's 7 years.
Yeah, so it's 2 years for the client documents, but 7 years for our professional development as FDR practitioners. As accredited mediators, it's not as clearly articulated, but clients come back, particularly in some areas, other areas not so much. But yeah, you want to, if people want to come back, you want to keep a record of what's happened before. If you're working with an organisation, have your history to a degree. Certainly from the point of view, if a complaint was to arise under the new AMDRAS standards, they can raise a complaint for up to 12 months after the last service you delivered. So you definitely want to keep at least that long, just in case if someone raises a complaint and you can't show that you've provided the mandatory information, that you followed procedures appropriately, then it makes it very hard for you to say, well, oh no, I did everything right. I've trashed it all.
Yeah. Trust me.
Yeah, trust me. Sure.
In saying that too, Jo, with part of what, and this is from my training with you at MI, apart from the documents that I save and whatever's scanned and returned to me in my client file, any of the emails that I send to and from and receive are also saved. I can actually go back to, and I also have a spreadsheet which shows whatever the person is, whoever the person is, the date and time of the phone calls and any emails to and from. So that's actually written down there so that I can then go back to that file. Oh, that was when I did that, plus a brief note of whatever it was about.
Oh, look at you, poster child. I wish I could give you a sticker. Yeah, because it's really important that you're thorough and careful with your case management. With our type of clients, they'll often disappear for a little while and then come back, and because they're stressed and maybe they go and get some mental health support and then decide, oh, I need to get this sorted.
So I'm happy to actually share that and send it to the team
template of how
that they can just put their own thing. They'll find it so helpful.
Oh, that's brilliant. Thank you, Jo.
I have from an intake, like a spreadsheet, I've got a couple. One has got an intake tab, and then there's the mediation. It shows in there the overall spreadsheet can show.
The other benefit, it makes it really easy for you to see how many practice hours you've got as well, because you can go back through that.
John had beforehand. I could try to find it. I didn't want to speak over you.
All right, we come equipped with 2 of them, so.
The information for up to 2 years. In my policy and procedures, I've got that the only thing that I keep is a copy of the agreement in case they lose it up to 12 months and then are discarded. Does that mean I have to keep it for 2 years now?
Yeah, look, it says 12 months. Some training providers say trash everything, don't save any of your files, but I think that's poor advice, because if you have a complaint, you really don't have any information about the case. If someone comes back, you don't have any information. The standards now say 12 months. Before, they weren't clear. Depending on circumstances, it may be beyond that.
Okay, so just in case, I should actually keep all the documents for 12 months then?
Yeah, your signed agreement to mediate, your intake documents, and you might make a file note. Certainly if something concerning happens, make a deliberate conscious file note. This is the date, this is what happened. So if someone accuses you of something, or people get very agitated and the other party says, oh, I'm frightened, this is not safe.
So should I change it from 12 months to 2 years now? 24 months to keep everything, or not necessary? 12 months is okay.
The standards for standard mediation don't require it, but I wouldn't destroy them on the day of 12 months.
Well, yeah.
Maybe.
After 12 months, if you remember it, also.
And look, if you're using a client relationship management or practice management software, you're probably not going to get rid of those old files anytime soon anyway. Lawyers need to keep their files for 7 years, their paper and other files. I've got a storage container full of my husband's.
Okay.
I did just check for you as I was reviewing the video about time limits. The standards aren't specific about how long you need to keep your records, but you may, as we've said, you may need them for clients returning. If there's a complaint, you need to keep your professional development evidence in case you're audited or in case your recognised accreditation provider is audited. And remember, your period's 2 years for your professional development, and then an audit obviously would come after that time frame. But one area to have a look at is in Appendix 4, the section about providing information to participants about the confidentiality of the process and any obligations to release confidential information in the specific dispute resolution process. So it has a fair bit of information for you there about respecting the confidentiality of the process. One of the things that it has in point E is a registered practitioner is not required to retain documents relating to a process, although they may do so if they wish, particularly where duty of care or duty to warn issues are identified. So that's where there was a concern. An RP must take care to preserve confidentiality in the storage and disposal of written electronic notes and records of the process. This includes taking reasonable steps to ensure that administrative staff preserve confidentiality. So it's you and anyone that's working for you.
Well, wouldn't that be if they basically come back for another mediation to continue from where they left off? Wouldn't they just be giving you the information as well for where they want to take off from?
Yeah, from a business management and client management, it's really nice if you know something about them. Once you start having a few clients, it's very easy to get them, think over their issues, sort of thing. So it's very nice to be able to refresh yourself. Although you will have to do another intake.
So probably the most important thing is that you don't share any information other than the agreement that they've got. That's the only thing and only between the two parties.
Unless they've asked you to send it to someone else.
To anyone. You don't share. That's the most important thing.
Yeah, and either the person who's provided the information, if it's like pre-mediation and they've asked you to send something off, or both of them have asked you, can you send the agreement to each of our lawyers or something?
Okay, so only if it's the original people or the lawyer.
Yeah, not just the lawyer. Oh, you did a mediation with someone. Can you send me the documents? Well, get them to tell me to do that, and I'm happy to.
Okay, thanks for clearing that.
No problems. And Jo, I think you had something to add.
I was just to add where keeping documents are concerned. I've recently had a few clients coming back to me and I said, okay, do you remember when? I go back to my files because I've still got them. I still have all their documents that I had sent them and their responses. And where there has been a mediation, I have that mediation plan, but they may or may not have signed it, or they may or may not have made it a consent order. So then should they choose to come back again, I've already got their plan. And often they'll say, oh, Jo, I've lost it. Can you send it to me? Sure, not a problem.
I had one today. The mediation was back in February and he wanted documents that were provided jointly. It happens. Software, CRMs, all of those with password protection. AI, just be mindful of what you're putting in. Maybe you think, oh, I've got this lovely spreadsheet like Jo's put together. I think, oh, I'll just put all that in and get some data crunching. Not if it's got all your client stuff in there, unless you're very sure that you've got a little caged AI that's not sharing information out anywhere at all. Make sure it's generic information you're putting in, not confidential information. That's all progressing very quickly.
I had an interesting thing happen with me the other day on that. Where I work, we have a co-pilot through a corporate license. We're also very careful about not putting any identifying information in. So when you put the prompt in, I've put a particular prompt and I asked AI to help me write something for this particular thing where I wanted to make a submission to my leaders about something in the business.
Yeah.
And it gave it back to me and it said, "Dear so-and-so," and it named my direct supervisor by their first name. It signed it off with my last name and my title.
That's why you've got to be so careful.
Yes, it's
A bit scary.
Yes, very pervasive. So we have to be mindful of that. These are the Australian privacy principles from the Office of Australian Information Commissioner. So they're really quite interesting and nice to have a look at if you're thinking about, is it okay what I'm doing in general terms, in marketing terms, and things like that. With mediation, we have those confidentiality provisions, so someone can't just rock up and say, "Can I have a whole file and everything that's related?" So you definitely, well, can I have the court order that says I need to do that? Other than that, you wouldn't. I think just a good reminder, particularly if you're engaging with marketing staff, sometimes marketing people can get a little bit excited and forget about some of these principles. No offense, Ro. Who's got a degree in marketing, but they shouldn't. I'm sorry. I don't mean to infringe the the integrity of our marketing friends, but yeah, just it's easy to get a little bit carried away. So we need to be very, very rigorous around that. Any thoughts? Has anyone ever had a look at the Australian privacy principles?
Yeah, not from a mediation perspective, but very aware of them through my normal job role.
You'd be bound by them in that role,
Yeah.
I imagine.
But
yeah.
interesting to look at opting into them because it could give a sense of a bit more security to people participating. It could give a point of difference in the market.
Absolutely. And you can opt in, you can choose to be, and then you're able to say that you signed up to that. So just something to think.
Out of curiosity, Joe, where do you sign up for that? Because I know with my documentation with the privacy and confidentiality, apart from what we have to do as mediators, I always tell people that under the Privacy Act, everything we say is private and confidential and not shared. The only time I would need to report with mandatory reporting is under certain aspects, where there is harm to child or others. Could you explain that a little more?
If you go to the Office of the Australian Information Commissioner, which is oaic.gov.au, they're the Commissioner administers the Privacy Act, and they've articulated that into privacy principles, which are mandatory for businesses over $3 million, certain large enterprises, health and other higher risk industries. But it has information about how you can opt in.
Okay.
So since we already have a very high standard, it's probably not that hard to meet that.
And I know where clients are concerned, Joe, that knowing that it's private and confidential and anything that we discuss is not discussed with the other party. Yeah. And any information that we write up is not discussed with the other party. It's up to them to bring it jointly to mediation where it gets that way. It actually gives the individuals, both parties, a sense of safety.
And it's really important to stress that and say it out loud for people so that they can understand, or if they're looking a little bit worried about it. Now, remember, I won't be sharing anything of this with the other person. It's up to you to bring that up in the mediation if you choose to.
Even in private sessions, Joe, where we were taught with MI that whatever goes between the mediator and the party is not brought into joint. They need to bring that themselves.
Yeah, absolutely.
The added twist on this one for me is that the privacy principles are pretty much around personal information, whereas the confidentiality in the mediation is around everything that is said, and it doesn't necessarily mean just personal stuff, but this is about what could be considered personal information. The scope of what can be considered personal information is quite broad when you actually stop and look at it. It's not as narrow as you might assume.
Yeah, exactly. And that's why I'd encourage you to go to this website and have a look so that you understand. We often talk about the Privacy Act, but have we actually looked at how it's articulated into the real world? I've put a little bit of a checklist together that you can access from my members' links. You can also download the accredited mediator logo unless you become an advanced mediator, but also the AMDRAS logo, and we've put together some little email signature ones that you can use as well.
Good.
There's, for people like you, Joe, that have got the FDR, there's one that's got accredited mediator AMDRAS, Family Dispute Resolution Practitioner.
And that's on the members?
In the members portal, yeah.
Great.
Under the members logos. And what else have I got? So here's a couple of things that we often have coming up. Over-servicing. Some of the complaints I get with early mediators is they spend a lot of free back and forward talking with people, phone calls, all of that. And because they're starting out, they're not worried about the money, they're just wanting to engage in this conflict stuff. But it's not good because generally it's going to be one that engages in that way more than the other, and you've got the risk of conflict of interest. Often it's someone who's very high conflict. If you've had a look at any of the Bill Eddy stuff, the archetype there is that they love you to pieces and you're the best person ever and you're an amazing mediator. Never met anyone who's just understands things as much until they turn on you. You're the worst person in the whole wide world. If there's a complaint, which they will make, and then you've got these reams of emails, not necessarily that you've done anything inappropriate in them other than you're out of your role. Like, it's not what we do as a mediator. If they need that, send them to a counsellor, send them to a support group, send them to mental health support, but don't do that as a mediator. Sorry to be so strong, but I've had a few of those, and I know people mean well, but they really get themselves in trouble. The other one is providing advice. Ideally, don't provide advice. There are options where you can. We had a presentation from one of our barrister mediators the other day. You can watch that. He talked about the pressure they often get from judges and from the lawyers who are wanting advice. Under the AMDRAS, there is clearly articulated you can provide advice in very limited circumstances where you are fully qualified. It's agreed in advance in writing that you're going to provide some sort of advice, but it must not undermine self-determination. As a mediator, even if you're in that style of mediation where there's a lot of information provided to you in advance, you don't have the information to fully determine a case. So providing your case is useless, just accept whatever they've got would never be appropriate for a mediator. How do you know? You're not the judge. That's not the role you're in. But, in the context, let's say it's workplace and you've got a lot of knowledge about fair work, such, you might provide some information. You might ask I think it's always better to ask questions and help the person to work themselves through. But if you're in a situation where you're going to provide more than just factual information, you really have to get that approved in advance and be qualified to do so. Yeah. Pre-mediation, please don't skip it. It's really important. If you don't do it, it makes your job a lot harder when you get to mediation. There are some forms of mediation, court ordered and that sort of thing. If you get a job with one of the courts, you may find that you just get cases allocated. You don't get much or any pre-work time. It's unfortunate. I think it's a lack of understanding of the value of that. Wherever possible, wherever you have control, please make sure you are assessing appropriately for suitability and all of the various reasons that mediation may not be suitable. Yeah, pre-mediation is the intake process. So whatever individual activities that you do with the parties before the mediation, providing them with information, getting information from them and preparing them for the mediation, for the negotiation, helping them to realise if they've got, really unrealistic expectations. So some of those Watner Batners, all of those things we might do. Yeah, there are some examples of some core pre-mediation documents as well, Craig, and I'll share those on screen in a moment. And we must provide accurate information about our qualifications and what we're able to do. So for people that aren't family dispute resolution practitioners, if you're working in the family law space, ideally you don't, but if you do, Be very, very clear that you're not a family dispute resolution practitioner. You're not covered by the Family Law Act. You're not protected by the inadmissibility provisions. And if it's related to children, you can't issue a Section 60I certificate. So if they can't reach agreement, they're going to have to go with a whole new mediator. You know, you can't tell the FDR, it didn't work out, just can you issue a certificate? FDR will tell you, get lost. I hope they'll need to go through the process again. So really think about what skills and knowledge do you have in family law, and current knowledge about family violence and risk screening in that context. So that's not the same as working with people like relationship mediation, where they're not intending to head to family court. Even so, you'd still want to make it very clear. So anytime you're working with couples, really be very clear that the work that you're doing is to try and help them resolve issues in dispute and hopefully renegotiate their relationship and move forward for many more years of bliss. If they aren't able to reconcile and do want to end their relationship, you can refer them to someone else.
What I was just going to say, Jo, is to reiterate what you were saying, where relationship mediation is concerned with the changes in the family law. We as mediators, and so too the lawyers, are required to check with the parties. Have they had relationships? Have they had counselling? Or have they tried to reconcile or ensure that they can sort their relationship before they come into our space?
Because if people's relationship can be sorted out and they don't need to separate, it's probably going to be better for everyone. But not if you're not understanding family violence, particularly coercive control, you can actually be an enabler of ongoing abuse, because that form of family violence is very insidious and sneaky at times. Key takeaways: review and understand the AMDRAS. Please make sure you check those domains and the code of ethics. Check your processes against those requirements and engage with your professional association. Ask if you've got questions. Get in touch if you're starting out in work and you're getting questions, you're thinking, should I, shouldn't I, if I've got an ethical dilemma. We would much rather have a phone call, a conversation, talk it through, than end up having to deal with complaints. So I will stop the share and I'll just, you popped that in, thanks, Ro. What I want to do is show you where these documents I've talked about are, so you can jump in there and have a look. I just need to log in. So MI members, once you log in, you'll find, you won't see this unless you're logged in, and you'll find there's a thing with links and resources. There's the document library. I've uploaded some of these documents so they're easy to find and you can download them straight away. So here's Craig. There's a few different styles of intake forms that you can use. We're very happy for you to use any of these for R&D, rip off and duplicate. And Jo, if you are willing to provide a copy of that template to use for your
information booklet,
not necessarily your information document, but the Excel spreadsheet template.
Oh, absolutely.
Yeah,
absolutely love to share that. That's really good.
And then here, this button goes through to the bigger document library. I've probably got more things than you will see because I'm an admin, but
I think the logos are in members' resources.
They are.
So you can click on
your
them.
member logos there. Obviously, you only download and show the one that you're qualified for. We have ethical obligations. There's also the larger accredited mediator and one that's sort of formatted to fit more neatly. So you're able to display those on your website if you're accredited. And then there's some other things that you can have a rummage around. Mediation venues, we had someone from Sydney. If you've got a venue like Jo, I don't know if you would be interested in subletting for anyone over in WA. If you know anyone that does have those, we can put those into the members area to let people know.
Where I have my office, I'm here during the week and on weekends because I have weekend sessions for clients that can't work during the week. I know there are some rooms that can be available, so I can discuss with the business station and I'll give you their link
for people. Now,
Yeah.
with complaint handling, we've got a little suite of documents there. It was in a folder called complaint handling. We try to be obvious. We've got our policy there, client information. We've got a couple of documents that help you with providing information to clients. You just click on the little button and download the file. You might find some of those helpful if you're looking at your policy. One's for AMDRAS members and one's for FDR, because there's different requirements, obviously, for what standards or regulations we need to consider a complaint against. And we started a little bit late, so on time-ish. Any final questions, thoughts, anything that you really wanted to know that I didn't cover? Well, thank you very much, everyone.
Thank you.
Thank you so much, Jo.
Thanks, Joe.
Okay, just for anyone who missed it, to access these resources, go to mimembers.au and log in. You won't see these unless you log in. Once you've logged in, you'll see up on the top menu, members. Click on that or hover over that and it will do a drop down and you'll see links and resources. From that page, you've got a button there that accesses the full document library. And if you scroll down a little bit, you'll see these sample documents that I talked about today. If you have any templates or similar items that you think would be useful for other members that you'd like to share, please get in touch, send an email to members@mediationinstitute.edu.au. We'll add any suitable ones to that resource for members. Okay, thank you. Oh, final thought, if you are not a Mediation Institute member but you'd like to be, just go to mimembers.au. You'll see a button there for Join MI. It's only $190 a year for practitioner membership, which gives you free for members access to our professional development webinars, access to the recorded webinars from past events, and access to all these wonderful documents and resources. Okay, thank you for listening. And if you're not already a subscriber to our YouTube channel, that'd be perhaps subscribe. We don't put all of our videos up for the public. You might have to be a member to access everything, but we do put some that are suitable just for general viewing up. Okay. Thank you.